The first thing I wanted to say before speaking about Re B was actually to give full credit to the 10 barristers in the family team at Garden Court who supported me in my appeal to the Court of Appeal from the first instance judge. Effectively, if you instruct a barrister at Garden Court, you actually get 10 for the price of one. And it really was on the shoulders of the Silks and the experienced senior members of the team that my arguments were formulated in the way that they were. I also wanted to acknowledge that Counsel for the Local Authority, Mr. Melser, at first instance and in the Court of Appeal, was commended by the Court of Appeal for not over-egging the pudding at first instance in relation to the local authority's application. He was very fair and professionally courteous, and indeed that the Guardian's representative was praised for her excellent outline of the law in her position statement at first instance. But dealing now with the background of Re B, effectively there were two children who are currently subject to these proceedings. There's Sam, who's a 9-year-old boy, and there is an 11-year-old older sibling called Samantha. Their mother's a drug user and the father's unfortunately passed away. They live with their maternal grandmother, who is 65, and she's been caring for them since Sam was 2 years old. And in fact, even prior to him being 2, she was his primary carer because of mother's challenges with drugs and her mental health issues. Mother had recently been in prison towards the end of 2019. There had been some concerns during the currency of the special guardianship order that the maternal uncle had behaved inappropriately, and indeed there was an allegation from Samantha that the maternal aunt had hit her as well. So in the context of those concerns pertaining to the maternal uncle, who also lives nearby and is also a drug user, there were interventions by the local authority and support put in, but the maternal grandmother had also successfully attended a course in relation to attachment in January, February in 2020. So it was a mixed bag. The grandmother did have some challenges, but she was coping for all intents and purposes. And my analysis of the case at first instance was that basically we were all in confinement, and some of the issues that had been bubbling away in relation to Samantha's behaviour, effectively, because she was feeling kettled in her home, she erupted. But that didn't mean that Sam and the analysis in relation to him meant that an ICO should be pursued in relation to him. And in fact, as you'll see, the local authority, when they first attended the hearing, they weren't pursuing an interim care order in relation to him in any event. So as I say, Samantha was having a difficult day on the 20th of March. The lockdown meant that she was screaming outside. She made an allegation that she'd been hit by her aunt. The grandmother and the aunt denied it. And effectively, the police were called, and there was a dispute over who called the police. And what happened was that Samantha went into police protection. And then on the 23rd of March, the maternal grandmother signed a Section 20 agreement for Samantha to be accommodated by the local authority. So on the 1st of April, the grandmother informed the local authority that she wished to withdraw her Section 20 consent and that she wanted Samantha returned by Friday, the 3rd of April. Now, what the Court of Appeal said, and they did it very carefully in the observations that they made in relation to the local authority and how the Guardian proceeded. But their first observation was that just because a parent or someone with parental responsibility indicates that they wish to withdraw Section 20, the Court of Appeals said that it would have been desirable for an attempt to have been made to agree a suitable timetable with the grandmother ahead of the service of proceedings upon her. That would have allowed her to take advice, and if proceedings were necessary, to file some evidence. So effectively, the local authority involved themselves with a knee-jerk reaction to the maternal grandmother indicating that she wished to withdraw Section 20. And whilst the Court of Appeal acknowledged that there are positives to the fact that the system can respond quickly to emergency situations, the speed at which the professionals responded in this context meant that there was a wrong outcome for Sam. And I'll go on to explain why. So the next set of issues to set out in chronological order, and it's important to set them out because what happens in the chain of events impacts on the Article 6 rights of the maternal grandmother and ultimately on the Article 8 rights of the maternal grandmother, Sam and Samantha. So the local authority hear about the maternal grandmother wanting to withdraw Section 20, and on the 2nd of April, they issue at about 1 o'clock. The guardian's appointed at 16:02. The guardian appoints her solicitor at 16:40. Now, later on, because the guardian's position statement was so detailed, the Court of Appeal did commend the guardian solicitor for being able to turn around such a comprehensive document in a short space of time. The maternal grandmother received her papers at 17:20. That's what the local authority said, and that's what's in the judgment. But the maternal grandmother's recollection was it was about 6 p.m. So my solicitor gets instructed at 18:05 on the 2nd of April. But the problem with that is that at 23:39, long after working hours, and I know we're all working longer hours in this COVID-19 pandemic, but I think all would accept that 23:39 is long after working hours. My solicitor gets access to the electronic bundle for a hearing that's due to take place in 10 hours. So obviously, he doesn't open that bundle until he wakes up and fires up his computer. And at 10:37 the next day, prior to pre-hearing discussions, the local authority filed a position statement, making it abundantly clear that their application made on the 2nd of April, as it pertains to Sam, is for an interim supervision order, and there is going to be an interim care order for Samantha. That's their application. They support what they are applying for in their position statement by referring to the social worker statement, which is quoted at paragraph 11 of the judgment in the Court of Appeal. And it specifically says that Sam is not considered to be at immediate risk of physical harm. And although there had been historical allegations against the uncle, that they were not pursuing an interim care order in relation to him, because their view was that the status quo would be able to be held in place and Sam could be kept safe. But unfortunately, at 12:48, the local authority informed the parties that based on the Guardian's position statement, the plan now was for Sam to be made the subject of an interim care order, but moved on the coming Monday, the 6th of April. And the reason why they say they weren't going to remove him straight away was because Sam had been presenting with symptoms of COVID-19, with a cough. First of all, my response to that was, well, if you're willing to move him on Monday, then that means that he doesn't meet the test for an ICO. And if you're able to put in support over the weekend, why can't you put in that support under your initial plan for an interim supervision order? The response was silence. I then asked for primary evidence as it pertained to the local authority's assessment that Sam was demonstrating symptoms of COVID-19 related symptoms. There was no primary evidence provided by the local authority. So the local authority then at 13:43 announced that despite Sam's cough, their plan had now changed again, that they weren't going to move him on Monday, but they wanted to revert to their other plan that he can be removed immediately. This is after obviously having a plan when they filed a position statement at 10:37 saying they wanted to have an interim supervision order in relation to him. I told the Court of Appeal that Mr. Melser was extremely professionally courteous, and I stand by that because he was responding to the flurry of emails that the local authority was sending him on the back of the position statement filed by the Guardian. And I'll go into detail about what the Guardian said in her position statement. But unfortunately, what the local authority observed was that the process that I've just described to you was it was hard to describe this process as anything other than arbitrary. And obviously we don't want to be arbitrary when we're dealing with vulnerable children. So as we know, Sam was ultimately removed from his grandmother's home at 7 p.m, the interim care order having been made close to 6 p.m. So once the local authority had indicated that they wanted to change their plan from an interim supervision order to an interim care order, this was very much on the back of what the Guardian had filed in her position statement. Now, I want to be clear that during the course of the hearing and the pre-hearing discussions, I had obviously been taking instructions from the maternal grandmother on the phone, but she's a lay person. She doesn't speak English as her first language. I didn't have the ability to take instructions over a video call with her. That wasn't part of her technological arsenal. And so I felt at a disadvantage. But what I was able to get instructions on was that the application for an interim care order, as it pertained to Samantha, she was now neither consenting nor objecting. And she was willing to agree the interim supervision order as it related to Sam. But unfortunately, that wasn't the end of matters, because the Court of Appeal noted that the Guardian, although she hadn't spoken to the grandmother or the aunt or the uncle, and indeed she'd not spoken with Sam or Samantha, the Court of Appeal were concerned that the voice of the child was lost in this hearing. And if you want to look specifically in the judgment, it's at paragraph 22 and 23, which make for sobering reading. So, in my view, the Guardian made certain assumptions in her position statement because she said in it that, and I quote, and this is a quote from the Court of Appeal judgment too, it was not clear where the mother is residing since her release from prison. The local authority statement refers to the children having unsupervised contact with her. But the difficulty with that being in the position statement, and indeed in the way in which it was communicated to the court at first instance, is that there was an undertone that maybe the grandmother and the aunt were somehow harbouring the mother in a way that exposed Sam to risk of significant harm. But the local authority themselves were not asserting that in their submissions or indeed in their case summary or their position statement. So the Guardian was concerned also in her position statement that due to the COVID-19 pandemic, that there were severe limitations in social work visits being undertaken because of COVID-19, and that Sam may be at risk if he returns home. And of course, I said at first instance and to the Court of Appeal that COVID-19 is not a reason to relax the high standard in relation to the tests that are outlined in the legislation and indeed the relevant case law pertaining to interim care orders. And the Court of Appeal agreed. So the Guardian went on to express that she was concerned that Sam may, and I emphasize the word may be at more risk of physical and emotional harm if he is left without his elder sibling. Now that's a difficulty because the local authority themselves were clear that the risk of harm to Sam pertained to emotional harm and not physical harm. So that there was a fault in the Guardian's analysis. The Guardian also made much of the fact that Sam had stated that his family matters were, and I quote, confidential. So her concern was that it wasn't clear whether he will actually disclose any concerns should they arise in the home. But in my view, that's an erroneous position and analysis for two reasons. One, no one was asserting that Sam was at risk of physical harm. That wasn't the local authority's case. Secondly, if he was physically chastised, there's no evidence to say that he would have been silent. So it's an assumption upon an assumption which led to a bad recommendation which was deemed to be flawed by the Court of Appeal. And so we all have to be really careful when we're making these assumptions. And the Guardian, the Court of Appeal went on to make a stark comment. They said, "We are surprised that the Guardian and the children's solicitor felt it appropriate to make a bold recommendation from such a low knowledge base." Neither of them had met or spoken to Sam or to his grandmother or to the grandmother's solicitor. The Court of Appeal were troubled by the lack of balanced analysis in the case for removal that was put by the Guardian and then effectively adopted by the local authority. There was no reference to Sam's wishes and feelings, so 101 stuff for a Guardian. The Court of Appeal dismissed the proposition that the Guardian said that during the current lockdown, it provides a reason for the removal of a child when none would otherwise exist. So the Court of Appeal observed that Sam's voice was not heard at a critical moment in the proceedings and his interests were not protected by his guardian. And so what we take away from that is that we really have to be quite hard-headed with ourselves and take ourselves out of this parallel universe in which we're currently existing and working, and think to ourselves, if I was in court, physically in court, would I sanction removal? And if the answer is, I'm not sure, then you might need to phone a friend and think about it. So, because the local authority aligned themselves with the Guardian erroneously, they put themselves in the firing line for criticism by the local authority. And in my view, it's a keen lesson for all of us that we should arrive at our position based on our own analysis and not simply rely on the logic or otherwise of another party. If the local authority had stuck to their guns and pursued an interim supervision order, then they would have avoided causing harm to Sam. And in the end, their decision to change their plan for Sam was described as being undocumented, unreasoned, and arbitrary. No one likes that kind of feedback. So there were warnings at first instance by the grandmother, and I want to go through them because for her, what she said was that I accept that Samantha can't be with me right now, but I know what it's like living with Samantha. And if you put Sam with Samantha, as the local authority and guardian are now saying you should, you're going to cause emotional harm to Sam. And she said, if you place Sam with his older sister, who is displaying this concerning behavior, it's going to be really problematic. And this ended up being like a prophecy, because on the 8th of April, the foster carer for both those children gave notice on the placement due to Samantha's behavior. And then because there was no available foster home for both of them, they were placed apart. And when I told the Court of Appeal about this development, one of the Lord Justices put his head in his hands, because he could just see how this chain of events has led to this boy who should never have been removed from his grandmother into 2 separate foster placements where he's living with strangers and no doubt feels extremely vulnerable. So at first instance, the maternal grandmother had also argued that she hadn't had much time with the papers, and she hadn't had a chance to speak to her solicitor. And this was important because it's in line with the case of Ries, which is a 2010 case, which was actually cited at Court of Appeal level, but also at first instance, where in that case, the case for immediate removal was neither formulated nor communicated to the mother in a proper way. And the Court of Appeal agreed with the grandmother when the case of McMichael, which was kindly given to me by Amanda Weston QC, which was a Scottish case in the European Court of Human Rights, where a Scottish mother and father had not been given proper notice of adoption papers. And it was held that their Article 6 and Article 8 rights had been breached. And I put that into the matrix of authorities when speaking to the Court of Appeal, and they agreed with me that getting papers at 2339 is not compliant with the maternal grandmother's Article 6 rights and led to a breach of the Article 8 rights of Sam. So the other point that the maternal grandmother raised at first instance was that she said, well, you know, I've been working with you. I did that course about attachment and I always let the social worker in, etc. And she even invited them to put CCTV outside her house so that they could check whether the uncle was attending. And she said, well, look, you know, you were going to remove him on Monday, or you were thinking about an interim supervision order as of yesterday. Why don't you put in some support like you were going to? And re-see last year, the Court of Appeal said the high standard of justification that must be shown by a local authority seeking an order for separation requires it to inform the court of all available resources that might remove the need for separation. Which is why, at first instance, I said, well, look, do the doorstepping visits, which you're obviously able to do because you doorstep the maternal grandmother to give her a bundle. And between the 20th of March, when the precipitating event took place, and the 3rd of April, you've obviously been keeping an eye on things. Why don't you continue to put in that level of supervision? And unfortunately, the Guardian's assertion that because of COVID-19, the level of supervision wasn't enough to secure Sam's welfare was what persuaded the judge at first instance. But the Court of Appeal accepted that REC had not been properly applied. And what they said is that although the judge at first instance had made reference to the correct principles, he had not correctly applied them. So in this case of REB, it was neither necessary nor appropriate to remove Sam from his care. Now, one of the things that the Court of Appeal said that led to the decision at first instance was that the recorder was working for something like 10.5 hours. And he had been having a flurry of documents, bundles. He didn't have a chance to read everything. And obviously, the hearing for Sam's case started quite late in the day and finished at 6 o'clock. He'd been working a very long time. And he's an experienced and respected recorder, but that the pressure he was under led to the decision that he made. So in that vein, I'd like to endorse what Alison Munro QC said by indicating that as an example of when we are tired, we are not our best selves as professionals. And therefore, I think we all need to be kind to each other and say, look, we don't have time or the energy, and it's not realistic to give full weight and energy to this case, so it needs to be adjourned. We need to look at it when we have enough time, because it's not fair to the professionals, and it's certainly not fair to our clients. So the Court of Appeal allowed the appeal, expressing the exceptionally pressurized circumstances in which all the participants found themselves working. And the Court of Appeal acknowledged that all the professionals had the best of intentions and that they did not question their dedication to the field in which we all work. So when thinking about what the takeaway lessons for us are, well, first of all, I want to say, whichever party you are, local authority, parent, guardian, you need to think about, have I arrived at my own position independently? Have I undertaken my own analysis of the facts and the legal framework? Because as we can see, when we jump on someone else's bandwagon, it's not always the best way of coming to reasoned decisions. The next thing is that if local authorities are dealing with Section 20 and parents, and they're worried about Section 20 being withdrawn, that doesn't mean that they need to respond with a knee-jerk reaction. They should attempt to sit down with the person with parental responsibility and come up with a plan so that there can be proper service of the relevant documentation. And then the person with PR can take legal advice, and proceedings, if necessary, can take place, but at least then the parties are on an equal footing. Now, there's lots of takeaway lessons for guardians. So prior to supporting an ICO, you need to make an attempt to speak to the primary carer or the parents and also the child. And where a guardian supporting removal, you must do your best to provide a balanced analysis. The Court of Appeal were very concerned that there was no reference to the emotional and psychological impact on Sam from being removed from his primary carer. Also in this case, there was no reference in the guardian's position statement in relation to Sam's wishes and feelings. And so what I want to really say is is that whatever your standards were prior to the lockdown doesn't change those standards. And what the Court of Appeal said specifically, and I quote, "We firmly dismiss the proposition that the current lockdown provides a reason for the removal of a child where none would otherwise exist." And that ties in with something I'm going to talk about in relation to Section 25 orders. But from the local authority's perspective, what are the takeaways for a local authority? Well, for a local authority, if you're coming to court with a change of plan, first of all, you need to have a statement in relation to why you're changing your plan, and you need to have a revised care plan. There wasn't even a care plan in relation to Sam, and that's not a surprise, because when they arrived at court at 10:37, it wasn't their plan to remove Sam from his home. But if you are asserting, this is the next takeaway lesson, if you are asserting that a care plan needs to change because of a child's health, then all the parties have the right to have sight of that primary evidence relating to that child's health. But in addition to having sight of it, they need to have time to process it and take instructions, because otherwise it leads to arbitrary decisions. Now, for advocates, it was a learning curve for me as well. So, for advocates, we have to remember that we need to make our applications for adjournment fully and clearly. And so if you're concerned that it wasn't fully understood when you first made the application, you jolly well make it again. Don't forget to apply for permission to appeal. And if you can, try and preload some of the reasons upon which you think permission should be granted if you get the sense that the first instance judge isn't going to be with you. And of course, if permission to appeal is refused, as it was in this case, then you must apply for a stay of the order if permission to appeal is refused. Although I'm told that it wouldn't have made a difference in this case at first instance. So the final takeaway is that when planning for a remote hearing, consider whether it's agreed between all the parties that the hearing format is going to be Article 6 compliant. Because what the Court of Appeal said at paragraph 35 is that, and it's an obvious thing, there is a qualitative difference between a remote hearing conducted over the telephone and one undertaken via a video platform. And what they go on to say is that a video link is likely at this time to be the default option in urgent cases, like an urgent ICO, like an EPO. And that must be right, because for the court to have a proper sense of what's going on, and especially where it relates to serious consequences for children, they need to have the best opportunity to understand what the advocates are saying. And you can get a better sense of things over video. Now, I go on to set out what Re-A says, but I'm not going to talk about it here because William has gone through it in fantastic detail. I'm grateful to William for that. But it was, Re-A came out on the same day as Re-B, and both Court of Appeal judgments should be read in tandem with one another because they complement one another. And so the final thing that I wanted to highlight is that the attitude of professionals in relation to how we conduct our work in the context of COVID-19 applies across the board. And so what I want to do is give an example of how potentially there could have been another appeal, because this week, in a case where I was acting for a guardian, the local authority sought a secure accommodation order for 3 months. And the sole reason that they asked the court, in plain terms, the sole reason was that because during the current pandemic, it will take longer for the local authority to find an appropriate residential placement. Now, there was no primary evidence before the court, and the local authority were not saying that the young person was at risk of absconding. The parties accepted that he'd made progress in secure accommodation and that he had been a model student. And so a fantastic guardian that I represented, called John Collins, successfully persuaded Her Honour Judge Redgrave that the Section 25 factors do not allow for a draconian order to be made in the context of the current pandemic, whilst the local authorities search for an appropriate residential placement. The court were persuaded that they can only make a Section 25 order in the context of the well-established legislative framework, aka risk of absconding, etc. And so the takeaway from that, again, is that COVID-19 does not mean that we can now restrict a person's liberty arbitrarily simply because the professionals need more time or they feel that they're under pressure because of the COVID-19 impact. And so what I'd like to really finish off by saying is that all the recent lessons of the case show that we must keep our heads whilst others may be losing theirs.